Generally, all permanency begins with a finding of MMI, which we'll go over, as well as the guidelines the board uses to determine permanent impairment. And then finally, schedule loss of use and loss of wage earning capacity, which are those determinations as far as a person's permanent degree of disability. And then the resolution of claims outside of the workers' compensation system via Section 32 settlements, as well as Medicare's interest therein. So MMI really is what begins this whole process of permanency, and maximum medical improvement is when a person has really reached the end point of their medical treatment. Their condition has generally plateaued at that point. Modern medicine has done all it can for them, and really they're not expected to change too much in either direction for the foreseeable future. According to the board's permanency guidelines, MMI cannot be determined prior to 6 months from the date of accident unless all the parties agree. Generally speaking, MMI occurs usually about 1 year after an injury to an extremity, or 1 year after surgery if the individual does undergo surgery, whichever is later. And in the case of a systemic injury, such as to a neck, a back, or the head, then generally you're looking at about 2 years from that date of accident, or 1 year post-operative, again, whichever is later. The permanency process usually begins by the filing of one of two medical reports. If it's the attending physician that is giving an opinion that the claimant has reached maximum medical improvement, they will file a C-4.3 form. Or if the carrier's consultant is producing this opinion of MMI and permanency, they will file an IME-4. The board provides for, generally speaking, two different types of final evaluation examinations: a schedule award for impairment to extremities, loss of vision or hearing, as well as permanent facial disfigurement. Non-schedule awards are pretty much provided for everything else and result in either permanent partial or permanent total disabilities. And these forms have been updated in May of 2018 to require the doctors to provide or complete one of two separate attachments, or sometimes both, depending on the injury sustained. So the first attachment here, schedule loss of use of a member or an extremity, is attachment A. And the forms are pretty much identical between whether it's the attending doctor or the IME providing this opinion. So I've arbitrarily chosen the C4.3 attachment here. Nonetheless, the doctor is to measure with a goniometer all of the ranges of motion that are provided in the guidelines for the affected extremity, as well as those for the contralateral limb. They're to indicate whether that contralateral examination findings and range of motion measurements are applicable, meaning has that other arm or leg been injured before, such that it should be rendered unimportant to this determination. The doctor is then to use the board's guidelines, apply any special considerations, and come up with a permanent impairment percentage. In the cases that don't involve extremities, so injuries to, as we said, the neck, the back, the head, internal organs, psychological issues, and so on, are generally deemed non-schedule awards or permanent partial disabilities. So here the doctor is to utilize the 2012 version of the board's guidelines. They're to look at the appropriate impairment table and assess a severity ranking in accordance with that table. The doctors are to complete a functional capabilities form where they indicate how much the injured worker can now lift, carry, push, and pull, how long they can stand, sit, and walk, and whether they can drive a vehicle or operate heavy machinery.